Hello and welcome to my consulting project presentation. This presentation goes over a current legal case against ChatGPT and its parent company OpenAI. ChatGPT was found to have been used in a legal case. This current court case began in March of 2026, in which the employer of a user has sued ChatGPT, stating that the software is practicing law without a license. In the original case proceedings, the user of ChatGPT had taken advice from the software to fire her attorney in the proceedings against her employer, and then used the legal advice options of ChatGPT to file hundreds of documents, further extending the court case against her employer. In another finding, it was determined that the legal advice given by ChatGPT to the user was incorrect. The plaintiff, the original user's former employee, is also citing that the software should have some options which alert the user that any type of advice does not take the place of legal representation. Some of the ethical issues found in this analysis come with legalism and also slippery slope. My findings are more related to slippery slope, meaning that the future ramifications of small issues could lead to much bigger issues. The stakeholders in this analysis include the users, which could include any users of the OpenAI ChatGPT feature, shareholders of the company, the OpenAI employees themselves, and also the OpenAI Foundation. Lastly, some of the shareholders include the local and federal governments. All of these stakeholders play a role and have significant outcomes related to this finding. Some of the ways that ChatGPT or OpenAI could help to resolve this issue and prevent further legal actions would include top-down organizational behavioral methods, bottom-up, or the Lewin's methods of unfreezing or freezing. Some of the advantages of each of these options include top-down, meaning that the organizational leaders ensure that this does not happen again. Some of the disadvantages for top-down include that many of the leaders may not have the up-to-date software knowledge and be able to implement this. With the bottom-up, one advantage would be that the software developers would have some of the majority, of putting together fail-safes. Some of the disadvantages for bottom-up would be that the leaders have less input. With the freezing and unfreezing method, this is such new technology that there may not be older methods that need to be unfrozen. This may not apply. My recommendation would be to follow the bottom-up method, meaning reach out to the software developers and then work to put in fail-safes and frequent reminders to users at each step of the search feature that any type of advice given is certainly not going to take the place of professional advice. Another thing that can be done is to make sure that any documents that are prepared have a statement across it stating This is a sample. Please refer to an attorney for full advice. This could help prevent this type of issue from occurring in the future. One of the issues with this court case is that it opens up the eyes of the public and also the local and federal governments to the fact that software is becoming so advanced that people are putting very much safety and security and scrutiny into it. And instead of reaching out to practitioners in the field, they feel confident in the advice that is given to them by the software. Unfortunately, this does not bode well for future legal cases unless this is stopped. Again, I recommend the bottom-up methodology to help ensure that fail-safes are put in place and to prevent any further legal proceedings or financial ramifications for ChatGPT and OpenAI. Thank you.